And ChristianBody.net, Cipriano Roybal is coming back with us here with American Liberty Ministry. And Cipriano, it seems like we've been going through the Bill of Rights here of late, and I believe tonight is the 8th Amendment. Is that correct?
Actually, it is the 8th, but I'm actually going to be doing the 8th and the 9th tonight because 8 is a real short one.
Very good. Okay. Well, Mark, would you like to pray and get launched here?
Yes, Lord, thank you. We welcome your presence for this meeting tonight, and we ask that you just anoint Cipriano's lips and loose his tongue to speak forth the things of God as you want to bring it forth for our nation and for the freedom and liberty of the rest of the world. In the name of Yeshua Jesus. Amen.
Amen.
Thank you, Mark. Go ahead there, Cipriano.
And you know what? I always like to start off with references to the founding documents and the scriptures. So I always like to start off with the Liberty Bell. You know, the Liberty Bell is really an awesome thing when you look at the Liberty Bell, because what's actually on that Liberty Bell, what's inscripted is proclaim liberty throughout all the land unto all the inhabitants thereof. Folks, that's right out of the book of Leviticus 25:10. Then, of course, if we go to the Declaration of Independence, one of the major scriptures for that is Romans 8:2. And when we go to the Constitution for the United States of America, one of the major scriptures is Deuteronomy 5:1. And when we get to the Bill of Rights, one of the other major scriptures happens to be John 8:36. So now we're seeing a reference of where these scriptures actually come from, which I always say is an awesome thing. So what we're going to do tonight, we're going to talk about the 8th Amendment, and I'm actually going to go ahead and just read it out to you because it's really rather short. So it goes like this. This is the enumeration in the Constitution. Oh, excuse me, I think I grabbed the wrong one here. Looking for 7. There we go. Let's see. Here we go. Here we go. It says here, excessive bail should not be required, nor excessive fines imposed, nor cruel or unusual punishment inflicted. So if anybody actually goes to court, this is the standard. And the reason why they set this standard was, well, before the revolution, you know, the king and his soldiers and all the magistrates and everybody at that time, they would actually impose really, really cruel punishment. I mean, you know, we talk or we hear about, you know, when one of our founders talked about give me liberty or give me death. When he rode, because there was horses back then. He actually rode into a little town in Virginia, and a guy was getting whipped, and he was talking about how bad it was and what he was seeing, a whip with little bones on it, and it was just tearing up his back, and he could actually see some of his bones. And so he was asking, what did he do that was so bad? And he said, well, he wouldn't take a license, and him and 11 other pastors in that around that city would not take a license that the king was imposing. And so this was the punishment that they were doing, and they felt that that was really excessive. And so this is the reason why we had the 8th Amendment. Of course, we don't look at it that way today. We look at it as, you know, you're going to be in jail for a long period of time, way beyond before, because the whole concept about our laws, the way it was created is created in common law. So in common law, you're actually innocent to proven guilty by your peers, not by a judge, folks, but by your peers. It's common law. The judge is there to administer the court of the people, because this is a government of the people, by the people, for the people. Therefore, if one of your other fellows who is a sovereign as well as we are, we're all sovereigns, that means we all rule. That means the only ones that can really judge a ruler is a ruler. Because if you look back to the Declaration of Independence, and we read in the Declaration, by the consent of the governed. Well, if you look at the definition of govern, folks, you are actually to manage, you are to direct, and this is your standing. Now, when we look at our government today, that doesn't function like the way it did, because now we're actually operating under what is known as administrative law, administrative courts, okay? And that's a different system. So I'm just going back to what actually was created and hopefully one day I hope to see it back again. But the idea is this is why they created the 8th Amendment. Now, from there, we're actually going to run a clip on the 9th Amendment. So we're going to go into that one. So let's bring that one forward.
To deny or disparage others retained by the people. This, along with the 10th Amendment, doesn't protect a specific right, like freedom of religion or due process under the law, but rather advances an interpretation of the scope of the Constitution and of government power. To learn more about the 9th Amendment, I talked with two experts. Kurt Lash is the E. Claiborne Robbins Distinguished Chair in Law at the University of Richmond School of Law. Jeffrey Rosen is the president and CEO of the National Constitution Center. He's written extensively on the history of the Supreme Court. Professor Lash, can you tell us a little bit more about this amendment? Why did the framers include this amendment in the first place?
The 9th Amendment, like the rest of the Bill of Rights, was added at the insistence of the states. Although the advocates of the proposed Constitution had claimed that the national government would have only limited enumerated power, the state ratifying conventions wanted that promise put in writing.
Originally, the Constitution didn't contain a Bill of Rights because James Madison said a Bill of Rights would be unnecessary or dangerous. Unnecessary because the Constitution itself was a Bill of Rights. It only granted Congress limited powers, and therefore Congress had no power to infringe free speech, for example, or religious liberty, and therefore wouldn't be able to do so. And dangerous, Madison said, because if you had a Bill of Rights, people might wrongly assume that if a right wasn't written down, it wasn't protected. But in response to objections by anti-federalists, that is, those opposed to the ratification of the Constitution, led by George Mason of Virginia, as well as Edmund Randolph of Virginia and Elbridge Gerry of Massachusetts. So those three guys said, hey, unless we include a Bill of Rights for greater security and safety, then we don't think the Constitution should be ratified. And in response to their objections and those in ratifying conventions, many of which demanded a Bill of Rights, Madison changed his mind. And he included a Bill of Rights, which he cut and pasted from Revolutionary-era state constitutions. And viewers and listeners can check those out at the Interactive Constitution. But then that raised an interpretive problem. Madison and others were worried if you just had a limited list of rights, 10 amendments in particular, protecting particular rights, people might assume that if a right wasn't written down, then it wasn't protected. And the framers didn't want you to reach that conclusion because they believe that our rights come from God or nature and not from government. Thomas Jefferson in the Declaration of Independence said we're all endowed by our Creator with certain unalienable rights.
And when you look at these amendments, our first 10 amendments, you'll notice that some address specific issues like speech and the right to bear arms. The last two amendments on that list, however, address broader issues of constitutional interpretation. These are rules of construction. The 10th Amendment declares that all powers not delegated away remain under the control of the people in the states. The 9th Amendment addresses the problem potentially raised by adding this list in a Bill of Rights. The 9th Amendment tells us that just because the Constitution lists certain important limitations on federal power, this doesn't mean that the federal government has otherwise unlimited power, or, as the 9th Amendment puts it, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And in this way, those two last rules of construction ensure that every subject not placed under the control of the national government would remain under the control of the people in the states and remain there as a matter of right. These amendments protect the people's retained right to local self-government.
So I've talked a bit about natural rights because that same notion of the idea that you retain natural rights when you move from the state of nature to the civil society is picked up in the language of the 9th Amendment, which says that the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. So one big theory of the 9th Amendment is that it refers to these natural rights that come from God or nature and that you retain during the transition from the state of nature to civil society.
All right, so can you give us a few examples of what those unenumerated rights that people have debated have been?
The paradigmatic source for identifying what unenumerated rights are protected is a case called Corfield versus Coriell. It was decided in the early 19th century, and it was cited repeatedly by the people who wrote the Privileges or Immunities Clause to the 14th Amendment to the Constitution. And basically, the Privileges or Immunities Clause says that no state shall abridge the privileges or immunities of citizens of the United States. And the question is, what are those privileges or immunities? And in trying to define them, John Bingham, who wrote the 14th Amendment, and a lot of other people said, well, some of the privileges or immunities include the rights written down in the Bill of Rights, but others are not written down in the Bill of Rights, and you can find them in the Corfield and Coriell case. They're rights that are fundamental, they're uniform from state to state, and they've been considered basic rights of Americans from the beginning. And some of these rights include the right to make and enforce contracts, to sue and be sued, to have basic economic rights, and also to have the benefit of the writ of habeas corpus, which is in the original Constitution, and that's the right to challenge the constitutionality of your conviction. It's in the original Constitution, but not in the Bill of Rights. So those are just some examples of the unenumerated economic rights that the framers of the 14th Amendment considered to be protected by the 14th Amendment and by implication by the 9th Amendment too, because they are natural rights, as we heard Roger Sherman say, the basic rights of acquiring and possessing property and obtaining happiness and safety. Those are some of those rights.
The 9th Amendment raises the difficult issue of how exactly you determine what the rights are that are actually retained by the people. And the text of the 9th Amendment itself tells us very little about the specific content of our retained rights. But in fact, these retained rights are as numerous as the stars in the sky. They include everything from wearing a hat to walking on the sidewalk to purchasing life insurance or determining where you can park your car or what classes should be offered in the local high school. Basically everything that was never meant to be handed to the control of the national government. All of these are rights retained to the control of the people in the several states. And all of these rights will be protected if you limit the scope of federal power. A limited interpretation of the Commerce Clause, for example, preserves the people's retained right to establish local educational policy and to pass all manner of local civil rights legislation that's not expressly covered by the federal Constitution. The greater the limits on federal power, the greater the freedom of local communities. And by making a limited interpretation of federal power a right, this ensures the matter can be litigated in federal court and not just left to political compromise. Over time, courts will produce a body of law that invalidates attempts by the federal government to regulate our lives in forbidden ways, such as not having the power under the Commerce Clause to force us to purchase private health insurance, or not having the power to commandeer state officials and force them to enforce federal immigration policy.
Does this refer back to some extent to kind of the common law of England and the things that were considered the natural rights of Englishmen?
Yes, it does. Although we should distinguish, if we're going to be precise, which we should, not all of the common law rights of Englishmen were natural rights. The common law rights basically are rights that were traditionally protected by English law. They're rights that had been recognized by English judges over centuries. Natural rights come from God or nature, not from government. And there's overlap between those groups, but there might have been some common law rights of English people that were recognized by tradition, like the right to jury trial, for example. That's not a natural right because there are no juries in the state of nature. They're just people who are, imagining forming governments. So it makes it a little tricky, but it's actually not that analytically tricky. And it's so interesting that over and over again, the framer said, this is just, everyone knows what these natural rights are. They're the ones that are recognized in Corfield and Coriell. They might, and then other enumerated rights might include the common law rights of Englishmen. But it was a pretty short list. And the best way to just figure out which rights were natural, go to the interactive Constitution, click down and look at those. Look at the Virginia Declaration of Rights. Look at the Massachusetts Constitution of 1780, the New Hampshire Constitution, which has this beautiful preamble about what a natural right is. And you'll just see that all of these state constitutions are recognizing the same natural rights over and over again.
So has the Supreme Court ever decided a case based on the 9th Amendment?
The first judicial opinion was actually written by Justice Joseph Story, one of the most famous justices in American history. In his opinion in Houston against Moore, decided in 1820, Story explained that the spirit and letter of the Ninth Amendment called for the limited interpreting of the scope of federal power in order to avoid interfering with state laws regarding the local militia. In fact, it wasn't until the 20th century that you find scholars and justices trying to invert the Ninth Amendment in a manner that allowed or even required federal interference with local policies. In Griswold against Connecticut, for example, Justice Arthur Goldberg argued that the Ninth Amendment supported the court's invalidation of state contraception laws.
Douglas says in this case that the Constitution and the particular rights in the Bill of Rights include certain penumbras formed by emanations from the particular guarantees that may create broader, unenumerated rights. And privacy was one of them. Douglas says privacy is protected in different ways in different parts of the Bill of Rights. The Fourth Amendment protects our right against unreasonable searches and seizures. The Third Amendment protects the right not to have soldiers quartered in the home. The First Amendment protects a right of freedom of association. And from these particular expressions of privacy, Douglas extracted or inferred a broader and more sweeping right of privacy, which could be extended to cover a married couple's right to use contraception.
When the Bill of Rights was ratified in the late 18th century, it only applied to the federal government. It was not until after the Civil War in the late 1860s, early 1870s, that the 14th Amendment applied some of the protections of the Bill of Rights to state governments. So how does the 14th Amendment impact our understanding of the Ninth Amendment?
Most constitutional historians believe that the Privileges or Immunities Clause was originally understood as applying the first 8 amendments against the states. But what of the Ninth Amendment? Is it possible that the Privileges or Immunities Clause turns the Ninth Amendment from a provision protecting local government to one that interferes with local government? Many libertarian scholars believe so. A close look at the historical record, however, shows that this is not likely. To begin with, John Bingham, the man who framed the Privileges or Immunities Clause, publicly declared to the House of Representatives that the Privileges or Immunities Clause made the first 8 amendments enforceable against the states. He said nothing about either the Ninth or 10th Amendments. Meanwhile, in the Senate, the man who introduced the proposed 14th Amendment to his colleagues, Jacob Howard, also said that the Privileges or Immunities Clause would apply the first 8 amendments against the states, and he too said nothing about the Ninth or 10th Amendments. And finally, the public that debated and ratified the 14th Amendment remained broadly committed to the Federalist principle of dividing power between the state and local governments. It had been the slave-holding rebel states that had violated this principle by demanding that slavery be enforced throughout the nation, regardless of local freedom laws. If we look at the period in which they adopted the 14th Amendment, it appears that that amendment did in fact apply the textual rights of the first 8 amendments against the states, but it left everything else to local control, subject only to the requirements of due process and equal protection.
Well, the Ninth Amendment, at the very least, is a question of interpretation. It says, don't assume that if a right isn't written down, it's not protected. So when Robert Bork, the late Robert Bork, who was nominated to the Supreme Court in 1987, but didn't get through, said that the Ninth Amendment should be treated as an ink blot because we can't know what rights are actually protected by the Ninth Amendment. It should be ignored. That can't be right. That's the one thing that Madison said, don't do. Don't assume that if the right isn't written down, it's not protected. But saying that matter of construction is important and that there are certain rights not enumerated in the Constitution that are protected doesn't tell us which rights are protected. And that's where all of the action and all of the drama and all of the excitement and constitutional interpretation in the 20th and 21st century has come from. How do we identify the rights that are not written down or not enumerated, but are protected? And there's a whole lot to say about that. And in fact, that's why we teach constitutional law, is to study the methodologies of interpretation that lead people to different conclusions about which unenumerated rights are protected.
So we've learned that the Ninth Amendment served as an assurance that the Bill of Rights was not an exhaustive list of the rights retained by the people or the states. But how can you protect unenumerated rights, which by their very definition aren't named in the Constitution? Kurt Lash sees the original meaning of the Ninth Amendment as a restriction on federal power. Jeff Rosen reminds us that although it's difficult to tell which rights the framers intended to protect with the Ninth Amendment, it's likely that those rights included the same natural, unalienable rights enshrined in the Declaration of Independence.
Alrighty, so that gives us an idea of what we've been talking about here. And so one of the things I wanted to clarify that they had mentioned is, or should I say maybe even failed to mention, they touched on it. They actually did go back in reference to the Declaration of Independence, and we did reference the thing about natural rights, or natural law. And one of the things that I'm reminded about that they didn't mention at all is, you know, in all the courts and a lot of the main buildings, whether federal, whether state, whether city, whether county, we always had the Ten Commandments on there. The reason for the Ten Commandments was because, you know, when Jefferson said about the common law, the common law is based on the ancient principles, and the ancient principles is the Ten Commandments. So this is what we're missing. This is the key piece that's missing when you talk about the laws of nature and of nature's God. Well, that's God's law. That's moral law. That's the Ten Commandments. It's not necessarily an unwritten law. It is written, but the key that they were looking at is why they call common law the unwritten laws, because the law is actually written in our hearts. We know really the difference between right and wrong, and are we going to actually then move forward in a right or wrong stance? So this is where in common law, if you're having an issue, this is why the individual that has done a wrong is called a wrongdoer, not the defendant. It's a wrongdoer because he did something wrong. Okay, and so that's the whole process. And the reason why this whole debate came about was because England, actually, the king changed from the common law, which is the common law I'm talking about, based on the Ten Commandments, when he decided to divorce himself from the church and decided to go ahead and create his own church. And that's the reason why many of them were leaving the British, would be the British, not just England, but all the territories that British had authority over. A lot of those folks were leaving and coming to America because they were being persecuted because they were wanting to practice God's law and common law the way it was actually brought up and taught in England before the king changed it. And so we adopted it. And so what happened is we had a conflict with the king, and that's the reason why there was a revolution. That's the reason why we have this topic today. And it's very interesting because I touched on the idea earlier about a government of the people, by the people, for the people. So who has the final authority? The people. Because if you listen very closely, every case that he talked about in the Supreme Court, or any court for that matter, that is not passed by the people is an opinion, folks. And he even says it, the opinion of the Supreme Court. This is an opinion. So when you actually go into pass law and common law, the people view not just the case itself, but the law. And they determined if they need to change the law, or if they need to just say, okay, the person is either guilty or he's not guilty, and whatever the order is. And what the jury does then, they give it to the foreman. The foreman then instructs the judge to do the order. That's common law, folks. So what's happened, if you go to court now and you're before a judge, well, you're not in a common law court. You're in a court of chancery. We call it in America, in which actually a court of chancery is actually a British court, but in America we call it the administrative court. That's really the court of chancery in America, which is a mimic of the British court of chancery. So this is what's happened in our history, and this is what we need to share and talk and educate ourselves about what really happened. Any comments, any thoughts at this time?
You know, Cipriano, am I on?
Yes.
Yeah. Okay. Yeah. There's several things here. This has opened up a lot of things that we have talked about off and on through the past sessions. But one of the things that clarified for me that to take it back to the beginning part of it is the difference between common law and English law, and the fact that much of our that English is our was the common law, was the traditional law practiced in England through centuries. It sounded like, but that's not necessarily natural law, because natural law is what we're talking about is the original law, which is the law of nature, the law of God, and it comes in from a different perspective, and is probably less limited than the common law. I mean, common law would have some definitions and things that were practiced and were passed down through the age to age, generation to generation. So that was really interesting to me to see that part.
I think this part is so important that we're going to go ahead and continue this particular piece on the 9th Amendment next week, because I think it's very important that we go into some more detail about, we're talking about cases and opinions, and the Supreme Court really just gives an opinion. They really don't pass law, but people follow it as if it's law. That's a misunderstanding. Right now we're very close to a couple of minutes, so of course we want to ask you all folks to just come back and visit us. Come back to christianbody.net, and of course all the other affiliates that he has. But in quick, about another minute, somebody, Mark, you got a comment there?
Well, I found the real significance for our day is the Supreme Court throwing Roe versus Wade back to the states, and people are arguing over that. But this is our right as American citizens for each one of the states to vote on issues like this. And I think that because of bad history, bad teaching, bad understanding, and that's why people need to watch Cipriano every week at 6:30 p.m. Mountain Time here at christianbody.net.
Amen. I agreed on that for sure, Mark. And thank you, Cipriano. I think we've had a good session here. We'll continue on. As we said before, folks can find this video and the whole series actually at CBNet Media on YouTube. It's also on Facebook and other places. It's not cataloged there, so you'd have to run it down if you are trying to find it. But go to YouTube and you can find it there. So thank you and God bless. See you all next week. Okay.